We close the chapter with the institution that sits at the center of regulatory politics, the Office of Management and Budget, the OMB. It's the President's principal instrument for coordinating agency activities, preparing the federal budget, and reviewing the regulatory output of the entire administrative state. The key subunit is OIRA, the Office of Information and Regulatory Affairs. OIRA is responsible for reviewing significant federal regulations before they're published in the Federal Register, with the authority to return rules to agencies that haven't adequately demonstrated that their expected benefits justify their expected costs. President Reagan formalized OIRA review by executive order in 1981, and ever since, administrations of both parties have used it to slow, modify, or block regulations the president found inconsistent with his policy priorities. The regulatory review process embodies the broader tension we've traced throughout this chapter. Agencies develop regulatory proposals through years of technical work, public comment, and legal analysis. That's the expertise side. OIRA review by generalist economists and lawyers at OMB provides a check on agency overreach, but it also creates an opportunity for political interventions that may prioritize short-term political considerations over the long-term regulatory goals the underlying statutes were designed to achieve. Two patterns are worth noting: deregulatory agendas. Systematic efforts to reduce the volume or burden of federal regulation have been a priority of Republican administrations since Reagan. Democratic administrations have used the regulatory process to advance environmental, labor, consumer protection, and equity goals. The second Trump administration's deregulatory effort has been among the most aggressive in American history, using OIRA review combined with executive orders requiring agencies to eliminate multiple existing rules for each new rule they propose. Now recall the major doctrinal change from our judicial branch chapter. In 2024, the Supreme Court in Loper Bright overruled the Chevron doctrine. Under Chevron, courts had deferred to reasonable agency interpretations of ambiguous statutes. Under the post-Loper Bright framework, courts, not agencies, interpret statutes when they're ambiguous. That doctrinal shift gives the judiciary significantly more authority over regulatory policy and reduces the discretionary space of expert agencies. It's one of the most important developments in administrative law in a generation. Let me close the chapter with the big picture. The interplay among Congress, the President, the courts, and the career bureaucracy in shaping regulatory policy illustrates the complexity of governance in the modern administrative state. No single institution controls the regulatory agenda. Congress sets the statutory framework but can't micromanage implementation. The President directs agency priorities but can't override clear statutory commands. The courts review for procedural compliance and reasoned decision-making. And the career bureaucracy implements all of this while bringing institutional knowledge no political appointee can fully replicate. The result is messy, contentious, sometimes paralyzed, but also remarkably durable across administrations with dramatically different priorities. That durability is, in many ways, the deeper achievement.